Still May 2nd at 50. We're continuing on S-126. And we're on the plans. So I'm going to work with legislative council around some language in ensuring that we have a valuable voice on primary care, mental health care, substance use treatment in our comprehensive statewide plan. And then we'll bring that back next week. All right. So moving on, we are on page 21, I think.
I think we're still on page 20.
I got it.
Identify. Right? Identify.
Oh, yeah. Things
There's
that,
opportunities and barriers. And I have our Jen Carvey, Office of Legislative Counsel, and I have that additional language, some version of the language from Medical Society around just adding another example in the administrative burdens. That's all I have in the way of changes. I know you have lots of feedback from folks, so I don't know if I'm missing anybody's.
I think C in this is really important, as we know. Everybody good with C? Federal, state, and other barriers to achieving the plan's goals, and to the extent feasible, how we can mitigate or remove them.
Okay, then we are on page 21.
Yay!
C, this language directs the Green Mountain Care Board to contribute data and expertise related to its regulatory duties and its efforts pursuant to Act 167, and the Agency of Human Services to contribute data and expertise related to its role as the state Medicaid agency, its work with community-based providers, and its efforts pursuant to Act 167. I will note this language, originated when the plan was going to be kind of jointly administered. So I don't know if it makes sense to list both of these, or to list more, or to flip the order so it starts with AHS, or if you feel like this is necessary.
Do we feel like it's necessary to direct the Agency of Human Services to use their expertise in something that they're doing?
I don't think it's necessary, but you could.
Go ahead.
And I think also the work of 167 now is really transformation, which is really Agency of Human Services, not Green Mountain Care Board. I don't think we need this.
I don't think we do either. Do we still need that the Green Mountain Care Board shall contribute its expertise around? Oh, no, they've already done that. Okay. Strike. Yes.
We would like to also include, so we had suggested, the language, Green Mountain Care Board should author the section related to health system finances, total cost of care, solvency of hospital systems, rate methodologies, and hospital global budgets. The Department of Financial Regulation should contribute to sections related to commercial players and payer solvency.
Okay, well, I can tell you we've taken out global hospital budgets, so they won't be contributing their expertise on that.
I think the AHS proposal is around who writes which sections of the, and not just contributing.
Are we on the
Yeah.
writing piece of the plan yet, or are we just on who's contributing?
And
And
I think we just struck C. So now we would be on to who does what,
okay,
what the process, at least as laid out in the bill from the Senate, from 2025 through 2027, as the agency engaging with stakeholders, collecting and analyzing data, gathering information obtained from the Act 167 processes, and soliciting input from the public. In 2028, preparing the plan, and then delivering it or presenting it by January 15th of 2029. And then also preparing an updated plan every 3 years to present to the General Assembly.
so it's in here that you envision that the paragraphs in the plan around those things that the Green Mountain Care Board has expertise in, that they're the ones that are, we're gonna write it?
Yes, and DFR, for parts of, commercial payers and care solvency. Because there are, some aspects of the board is the subject matter expert as well as the Department of Financial Regulation. And so we really need that technical assistance from them directly.
I don't know how other people feel about that, but I am fully in favor of our agencies of Human Services, DFR, and Green Mountain Care Board working together in a more collaborative manner in the areas of expertise that they have, since they often don't always align. So I'm fully in favor of that. Is the Green Mountain Care Board be okay with doing additional writing?
We would love to be able to contribute the work that we have. I think the agent has spoken to the fact that, contributing data and things that we're working on, it would depend if it was brand new work or something that we're not already doing, that would create a workload, pressure. But I think we would definitely be willing to share the work that we have. The only other thing that I'm sure that in committee that I would recommend is that when we contribute, let's say, a report or data, that we get to do that independently. That I wouldn't want to like contribute writing to something and then have it be edited that it wasn't our original work.
I see.
Does that make sense?
Yes.
So
And we certainly don't want to misconstrue, something that's highly technical that they're the subject.
yes,
Appreciate
that.
So
So I don't know if you want to get as specific as who is authoring which sections, or if you want to, have the agency prepare the plan, perhaps with, technical assistance from the Green Mountain Care Board and DFR or whoever you want to put in charge of it.
how about something to the extent that the Green Mountain Care Board and Department of Financial Regulation will contribute sections appropriate to their
Current workflow.
no, their expertise.
Yeah.
They're within their expertise.
And in their, I don't know, purview of what they do. How do we say that?
Well, I think I'm trying to understand whether the board is suggesting that they will provide sort of assistance to AHS in writing the sections that are about the board, or whether the board is saying they are willing to take on responsibility for writing the sections of the plan that relate to. I mean, I'm just not sure it's, a lot of this is broader than very specific. I don't remember what the list was from AHS of what they want the Green Mountain Care Board to write, but other than total cost of care, I'm not sure most of this is talking specifically about what the Green Mountain Care Board does.
System finances, total cost of care, solvency of hospital systems, rate methodologies, and hospital global budgets.
Most of that is not what the plan is talking about. The plan is a healthcare delivery strategic plan. It's about promoting access to care. It does talk about annual total cost of care targets. It's building on a lot of past work. It's identifying gaps in care, looking at opportunities to reduce administrative burdens, and identifying barriers to achieving the plan's goals. I'm just not sure what you would be specifically putting on the Green Mountain Care Board. I think it's more of a collaborative effort that is being led by the Agency of Human Services in figuring out how to address these delivery issues.
Could we just have in there that the Green Mountain Care Board will contribute on total cost of care?
We need to have it at all.
What, total cost of care?
No,
No, the whole thing.
Who does
Who does what?
what on which pieces?
Let them figure it out.
Okay, all right. So we'll let them figure it out. Great.
Or maybe it'll come out of rule, who knows, but not statute.
I know there was some potential interest in revisiting the timeline that is in subsection D, so key that up for your discussion.
I am, anyone have any feelings around the plan shall be delivered by January of 2028?
A long time away. That'd be great.
What's that?
It'd be great if we got it then.
Yeah, it's too long.
It's too long.
Too long, right?
It's too long because let's not forget, in the beginning of the bill, we are tasking the Green Mountain Care Board for using this plan as one of their metrics they have to follow in the things that they're working on. So the sooner the better. And it is now May of 2025. If this bill passes, it will be in effect, I don't know, on passage or in July, whichever comes first, who knows? And that is 2.5 years. Yeah, Daisy.
I totally agree. I think every day we come to this building because we are in a healthcare crisis in every single one of our districts. The Agency of Human Services, it is their job to address that crisis every day as well. I think my constituents don't have 2 years. And I know that there are many competing priorities and responding to that crisis, but we will never catch up to it if we don't have a plan for how to do that.
And by their own testimony, they're already working on this.
But we need to do that collaboratively. So I think we need to have something a little more realistic in terms of a
Do we
goal.
even need number 2?
We're
Telling
trying
them
to-
when
trying to
they
set
shall
up the
prepare.
timeline, so no, not necessarily. I think it was trying to create a bit of a timeline for the work.
Okay.
But
We could say from 2025 through 2027, they shall do all of this and solicit input from the public and prepare the plan
Yeah, finish it by when?
on or before January 15th of 2028.
I want to see a preliminary plan in there.
I think we have in, don't we have in the report backs that they have to give us updates on where the plan is?
updates on the status, yes.
So we could put in a preliminary plan in January of 2027, where they are.
Plan to the community.
I would like to see, this is my own, you know, I would like to see not the preliminary plan, I'd like to see the plan in 2027. The update could come in those years that 25 and 26.
I hear you. I love your statement. I
Thank you.
just,
I love it too.
just let's. Is there, I'm gonna tell Leslie and then I'm gonna hear Leslie and I'd like comment on 2027.
You can't see it, but Representative Tina has his hand up.
Oh, I can't.
It shows up on my.
Thank you. I had given up and just taken it down.
I'm sorry, your name unfortunately isn't up on our corner of our screen, so I don't see it.
And I just want to say this for the sake of time without running to the room, that that I think we need to see, we've heard that there's already something that exists that is being, that, you know, like there's already work being done on a plan. I think we need to see that work at the beginning of the next session so that we can weigh in on it. Like, And I would like to see the final product by 2027. And then furthermore, I'd like to talk about this more later, but in 2026, the state contract with WellPath ends, which is a $121 million contract for corrections healthcare. That's 30 million a year we're spending on corrections healthcare that's inadequate. There's no reason that 30 million a year can't be recaptured and funneled into our existing healthcare system in Vermont. And if this plan is not ready by 2020, if there's not some kind of preliminary plan in 2026, what we're going to hear is we have to have an out-of-state contractor yet again for another 3 years. So if we can get this plan in order, and if we can get some language in this bill to make sure they take into account corrections healthcare, that's 30 million a year that we could funnel back into our local providers. Thank you.
Thanks for your comment, Brian. So how about we, okay. I was gonna make a proposal really quickly.
Don't
How about
mind.
we say from 2025 through 2026, they shall do this. On or before January 15th of 2027, they shall present the plan.
That's what I was gonna say. I think time is like a gas. It expands to take the area that is given, and if we give all this time, that's what's gonna take. So I think we need to move it.
Can I just ask a quick question on the timing of the legislature? Are we this, I mean, it's not our body, but is it the same body coming in? Like if,
It would be.
is it a newly, not this body?
Yeah, in 2027, there will be a newly, it will be.
But would it be first or second?
First year.
First year,
Yeah,
okay,
first year is the.
okay, thank you.
From 2025.
Change 27 to 26.
No, I was just gonna say if it
That's what you
was,
said.
sorry, I was just
It will
gonna,
not be this,
well, I know it won't be
Yeah.
this committee, but if it was the second year of a session, I was gonna say we get it in December.
first
But if
year.
it's not, okay. Sorry for that. Rabbit hole.
Everybody good on dates?
So what the date is change it from 2027 to 26?
And
that right?
So-
25,
So are you adding in preparing the plan as part of the 25 and 26 work?
Yeah.
And then it's, yes, I'm sort of wondering if we need honestly, any of the dates before when it's presented, if you're not creating the kind of timeline.
Okay.
I agree with that.
So you could just say on or before January 15, 2027. It will present.
So we'll just
Get rid
say
of D1 and 2.
AHS will do all of these things. And then on or before January 15th of 2027, they'll present the plan.
Years earlier.
And then update every 3 years after 2027.
How about every 2 years? And then every single new committee will get the updated plan. Everybody good with that? You're not?
Well, I think that there needs to be something added about actually a yearly check-in about quality improvement, what's known, what the continuous quality improvement actions have been.
So that may go, you may want to put that in annual in the reporting.
I'm happy with that. I just think it needs to be
Yep.
somewhere in there that we get an annual.
Make a note.
Yeah.
No, it is very clear that we want this plan and we want this to be an iterative plan
Yeah.
that changes and is adapted and updated.
Using
and
quality,
is alive and
I'd like using quality improvement science methodology. That's just me.
we'll do that when we get to the reports back.
I'm just thinking about the timing issue Representative Houghton raised around first and second years of a biennium. Does it make sense for the update to start? I'm just thinking it may make more sense for a returning legislative committee to get an updated report, in December or something preceding the even numbered year when you're coming back, so that you already are grounded in the healthcare system rather than having new people trying to understand the system and how the new plan, updated plan fits into it.
Okay.
So
Beginning December 15th, every,
we'll do every 2 years, we present, and I won't say present, we will say provide it to the General Assembly on or before December 1st. every other year starting. So would you want to get that then? Maybe we start it in December of 28?
Yeah.
On 2028.
It's a birthday.
Oh,
I look forward to birthday.
what a
present every
birthday
year.
present.
I'm like, look, it's the plan.
okay, we finished section 8.
Oh,
I think you may have your
yeah,
Rutland witness. Is this a good time to?
yes. Is it a good time? Is he in
Yeah.
person?
Yeah.
Okay, but on the Zoom also, apparently.
No,
It's probably.
I don't think so.
Yeah.
Will Dempsey from AHS.
It's again, really quickly, just so that I have in 13 minutes.
Yeah, Jen can update the dates while we get our witness.
And they're testifying about what topic?
Different bill, S63.
Thank you.
Thank you, Jen.
Thanks, Jen.
Coming all the way up.
Thanks for having
Yeah.
us. Glad to be here.
Good.
Oh,
Well, the whole crew.
Hi, how are you?
Good.
Welcome.
Thank you so much.
I apologize. I don't have my agenda in front of me. Michael. Michael, nice to meet you. Thank you for being here. So we've been working through on S63 and we heard testimony from the Green Mountain Care Board. And you had asked to come in and speak to it. So welcome.
Thank you. Thank you, Chair Black. Thank you, members of the committee. I'm Mitchell Baruti. I am the Vice President and Chief Legal Officer at Rutland Regional Medical Center. And I want to begin by expressing our deep appreciation for the thoughtful and difficult work that everyone in this room is doing to help stabilize Vermont's healthcare infrastructure. We know these are complex issues and there's no magic wands. And this committee has shown both persistence and dedication in the face of a healthcare landscape that continues to rapidly evolve, and we're appreciative of these efforts. I also want to recognize Chair Foster and the Green Mountain Care Board. While we may disagree at times and on the specific subject, which I'm going to speak about here, our RMC respects and appreciates the GMCB's commitment and effort to ensure a more sustainable healthcare system in Vermont. I'm here to speak to the proposed amendment to Section 7 of S63, declaring that proceedings to review, establish, and enforce hospital budgets are not contested cases under the Vermont Administrative Procedures Act. I'll refer to it as VAPA. On its face, this proposal may appear to streamline the process and be a common sense mechanism to create efficiency. But in practice, we believe it would erode a fundamental principle that should not be compromised or withheld, and that's due process. The committee has heard that there is a process, and Rutland Regional does not dispute this. We've participated in that process. We've submitted the data, we've received the notices, we've welcomed the dialogue, and we've raised our objections, and as we were told we could. However, we do not believe the existence of a process automatically equals procedural due process that also results in fairness under the law. When a state agency takes retrospective action that reduces a hospital's revenue and scrutinizes its past decisions and imposes corrective steps based on complex factual determinations, that is not policy, but adjudication. And adjudication under Vermont law requires contested case procedures. It is not an accident that these procedures are required because Vermont is a state of due process and fairness. Under 3 VSA 801(b)(2), a contested case is defined as any proceeding in which the legal rights, duties, or privileges of a party are required by law to be determined after an opportunity for a hearing. And that is precisely what hospital budget enforcement actions are. Now, you have heard that hospitals don't have the right to violate their approved budget orders, and that's true. We don't. But that framing also oversimplifies that reality that the reality of healthcare delivery in a dynamic system. And let me give you one example here. When patients travel outside of their designated service areas for care, and this is often out of clinical necessity or provider reputation or a host of reasons, this could generate unanticipated revenue that places a hospital out of compliance with its approved budget. The board has in the past still enforced the budget, appeared to overlook this evidence, and decreases rates and net revenue for the hospital as a result. Should a hospital in good faith serving patients it did not anticipate face a financial repercussion without the opportunity to test and cross-examine the facts, present evidence, and challenge assumptions? In this example, this is more than just enforcement. This is adjudication of a legal right. And it is not black and white. And that's exactly what VAPA was designed to address. The hallmark of procedural due process is not just the opportunity to be heard, but to be heard by a neutral arbiter with the opportunity to present and challenge evidence. The proposed amendment removes these core protections, in our opinion, leaving hospitals subject to enforcement actions without the full panoply of rights that due process demands. Without these safeguards, like I said, cross-examination, a formal evidentiary record, and decisions based solely on the record, this exposes the process to error and potentially unfairness, and it denies hospitals like Rutland Regional Medical Center the very procedural protections that are already extended to certain utilities, insurance companies, financial institutions operating in the state, whose budgets, rates, and premiums are also subject to regulatory approval. These organizations in Vermont all receive due process protections and enforcement actions through VAPA. Therefore, we believe hospitals should not be the exception, particularly when the stakes involve not just dollars, but communities. This is not about special treatment for hospitals. It's about equal treatment under the law. It's about fairness, accuracy, and integrity of the system that must be built not just for efficiency, but for due process. In the current process, there is correspondence, as the committee knows, detailed communication and hearings. But transparency is not just about what you're doing. It's about creating a record that can be reviewed, challenged, it's equitable, and it's trusted. And in a contested case, decisions must be based solely on the evidence presented. And that's not a burden, that's actually a safeguard. And without the framework, decisions can be made on untested assumptions or data that one party never had the chance to question. This leads to concerns over arbitrary and capriciousness in the decision, which then leads to, unfortunately, avoidable litigation. And that is not how we want to participate in healthcare. I don't think anyone wants that result. You've heard that contested cases are not always efficient, and that is also correct. They require time and preparation. Unfortunately, getting it right is not always efficient, which is especially true when a state agency acts as both prosecutor and judge. If the contested case requirements of VAPA do not apply to these hearings, then there's unfairness. And without the VAPA structure, we create a system where the same entity proposing an enforcement action is the one rendering the verdict, with no procedural firewall, no neutral decision maker, no evidentiary testing. And that's not just inefficient, it's a total lack of procedural due process absent VAPA. And yes, contested cases do take resources, and that is unfortunate. But removing contested case requirement applicability and enforcement actions would actually make the hearings more ambiguous and potentially result in even more litigation, challenging the elements of the process and rationale of the decisions. There is a structure and clear procedure, as I've said, with VAPA, and without VAPA, the structure turns to uncertainty, the uncertainty turns to ambiguity, and the ambiguity turns to litigation. And it would be less costly to just have the contested case in the long run. The burden of continued litigation falls not just on hospitals, but unfortunately on the courts, on the Attorney General's office, and on taxpayers who fund these. Rutland Regional does not contend also, just to provide clarity, that this amendment, if you do move forward with this amendment, that it would retroactively affect the pending litigation. We do not believe it would, and we agree with Chair Foster. Our concern is forward-looking. We want to ensure that future enforcement actions, no matter who they involve, are conducted fairly, transparently, and in accordance with the rule of law with a defined procedure which already exists in VAPA. This is not opposing oversight. It's about ensuring that oversight operates within a framework that Vermonters have long relied upon to protect fairness, transparency, and accountability. Due process is not a discretionary principle. It's actually a cornerstone of our legal system, and we strongly feel that it must be preserved. Thank you to this committee again for this difficult work and during a very difficult, uncertain time. We all want to build a more sustainable healthcare system and one that works not just for today, but for generations to come. And we welcome collaboration with the committee and also with the Green Mountain Care Board to create a stronger procedure that outlines compliance with VAPA, but also may provide streamlined options such as arbitration, for instance, in enforcement hearings. We're not asking for special treatment. We're simply asking for a fair adjudication consistent with due process if the time comes that an adjudication is warranted. And we ask that you please keep the contested case protections in place as a result.
Anyone have any questions?
Only that if you submit your.
Be glad to.
I think if you could provide a little context and keeping in mind that we're the healthcare committee, not the judiciary committee. So we have statutorily required the Green Mountain Care Board to set essentially hospital budgets as our regulator. So if they have set a budget for you and a net patient revenue, and you have gone over, what other mechanism do they have in order to do their statutory regulatory duties rather than enforce the budgets? And in the case of Rutland, did they come and ask you for a check for how much you were over?
So we believe that the statute, it does provide for the enforcement, and we don't challenge the fact that they do need to engage in their statutory duty. If a hospital goes over that budget, especially if there's no cause, then we would believe enforcement is warranted, but it does need to go under the process, the VAPA procedure, which allows for the presentation of evidence because the facts may be interpreted one way by the Green Mountain Care Board, but fact is, there could be people coming in that were not anticipated, that it's caused that revenue to go up. So should a hospital be penalized for something they could not anticipate, they truly could not? That's the question. So having VAPA allows that evidence to go forward. The Green Mountain Care Board can provide their evidence, and then hospitals can cross-examine that evidence to prove their case to ensure that the result is fair. They're not just being enforced.
Well, let's though remember that this is excess revenue. So it's not as though, yes, you may have gone over with good reason, increased utilization or whatever it might have been. But, and we say excess revenue, I can't think of another. So your profit was higher. Shouldn't the Green Mountain Care Board be able to then look at your hospital budget for the next year and say, we'd like you to use that profit that you made, that you were over, we understand the reasons you were over, we want you to build that into this year's budget? And isn't that really what they're doing with their enforcement?
And we believe that is what the statute allows them to do. And I don't contest that they are allowed to build that. For instance, a FY23 enforcement action, they are allowed to enforce that in a future year. And that's what the statute says. And we stand by the statute. But we also believe that decision shouldn't be made in a strict liability context. There should be actual process to reach that conclusion because there could be defenses to why that actually happened. Having that adjudication requires the back and forth, the cross-examination, bringing witnesses to be able to prove that case before that legal right has been determined. And that's why VAPA is so important, because it puts everyone in a room. It provides fairness. We all know the rules. If the Green Mountain Care Board does not give the decision that's favorable to Rutland Regional, if we're under VAPA, we know the procedure and we know the process and we've gone through it, we can respect that decision. And that's not going to cause the litigation. If we know the rules and everyone's abiding by the rules and the procedure and it's fair, we'll accept the result.
So what caused the litigation?
So unfortunately, and I have to be very careful, as you know,
You have to
speaking on this.
justify.
Yes. So there is VAPA on the books, but there's ambiguity in the board's perspective as to how it applies and whether it applies. And so if this committee decides to fully draw it out, that removes any hope that VAPA will apply moving forward. In fact, at some point, we would ask that it's clarified that VAPA does apply because it is so important. So ambiguity exists because what is the actual procedure? Hospitals believe the procedure is one thing because that's how we read the statute. The Green Mountain Care Board believes they can put rules in, follow parts of VAPA, ask the questions, do the letters that Chair Foster referenced. And part of that is correct, but it's not the complete process that guarantees fairness, equity under the law that we believe exists under VAPA and how the statute reads. We believe the statute requires VAPA.
Leslie?
Yeah, I understand your point. But I'm wondering, you mentioned increased revenue from utilization. What about increased revenue from excess pricing? How does that get folded into the decision-making that the Green Mountain Care Board is addressing in your excess revenue problem?
Is there any more clarity you can provide?
Well, I'm just thinking about what contributes to increased revenue, and that's utilization and prices. So how does Rutland Regional think about prices when their revenue is excess their budget?
Well, the prices, and that should be set at the time that the budget is approved. The revenue that's coming in is unanticipated, but the prices
are
anticipated.
But are you adjusting prices?
I would have to ask our CFO to apply to that.
I mean, that's what I'm wondering. I understand you're talking about due process, but I think it's complex beyond just utilization. I mean, yeah.
And I mean, to your point, I mean, I'm trying to understand what difference does it make what the excess revenue is from? It's excess revenue. And how does the Green Mountain Care Board assert their authority without having with the knowledge that every single time they enforce their authority, someone will take them to court? You're the chief legal officer for Rutland Regional. May I ask how many attorneys Rutland Regional employs in their legal department?
Yes. So we have myself and Deputy General Counsel Betsy Glenn is here as well. So we employ in-house 2 attorneys. There's certainly external counsel for various matters.
Right. And there's 14 hospitals. And how many attorneys how many attorneys have we appropriated to I should say we have appropriated because it's the legislature that appropriates. How many in-house legal counsels have we appropriated to the Green Mountain Care Board?
General counsel, staff attorney, and then there's some that do the work on the con.
Okay, so specifically for CON. I guess how do we address this without acknowledging the resources of the Green Mountain Care Board to be able to fulfill their mandate?
Not sure I have the answer right now, but I'm happy to get back with the committee.
Mari and then Daisy.
I have to say I have concerns about what I heard as your characterization of the current process with enforcement from the Green Mountain Care Board, which is in statute, that there's no transparency, that there's not an opportunity to be in the same room with the Green Mountain Care Board to talk about the excess revenue and the enforcement decision, and that there's lack of clarity. From what I understand, there's all 3 of those, that there is clarity about the process in statute, that there is opportunity for hospitals to communicate their concerns and other questions with the Green Mountain Care Board, and that there is transparency.
There's not true cross-examination, though, of the evidence. Hospitals are not bringing witnesses the way VAPA would allow it. And I'm not under the impression that that would be allowed in these hearings. But all the procedures of VAPA are not applied. And then you have judge, jury, and prosecutor making the decisions, which kind of removes the fairness from the process. And so that's why we believe VAPA truly needs to apply to these hearings, because it guarantees that fairness to every part of the process. There are parts of the process that do incorporate, there are pieces of VAPA that do occur, and we believe that to be true. Letters, notices do go out, but we believe, for instance, the hearing in FY25, it brought in the FY23 enforcement commingled to the actual budget review. It was one hearing, was not super formalized. What are we talking? Are we talking about enforcement? Are we talking about the FY25 budget? It was not structured in the way that gives you the opportunity to follow the procedure that we believe VAPA provides. And that causes confusion.
Easy.
Speaking of confusion, did I hear you say that you believe the care board is interpreting policy differently than your legal team is?
There is confusion right now, and I'm going to be careful with how I say this because of current litigation, but how VAPA applies.
Okay, so
Reading the statute, it applies one way. The care board has taken parts of VAPA, and some of these pieces do occur, but not all of it occurs, in our opinion. And we believe it applies. The care board does not, from my understanding, believe that it applies.
that sounds like poorly written policy to me. Do you agree?
The statute could have greater clarity than it currently
Okay,
has.
are you here to ask for a change in policy? If you aren't, why not?
So today I'm here to speak. I'm here to respectfully ask the committee not to proceed with Section 7 with the amendment. Please don't do that today. However, if the committee would be open to language to make this stronger, make this better, especially if it was a collaborative effort with the Green Mountain Care Board and the committee, we would be happy to be a partner. We would be grateful to provide language to the committee to help make it clearer and to make it stronger.
Madam Chair.
Tupper, yes.
That suggestion has already been made. I made it. And I don't see any result in the way you want it right now. So the reason I say that is, to me, it would be a waste of your time to develop that language. Unless the chair disagrees.
No, is your contention that the statute around budget enforcement is ambiguous?
The statute should clearly say, in our opinion, VAPA apply, the rules of the Vermont Administrative Procedures Act apply to budget enforcement hearings.
What if it says it does not apply?
And that's problematic. And that would be this amendment essentially that pulls it.
But it would make it less ambiguous.
Would certainly make it less ambiguous. Just it would remove the procedural due process that we believe should exist in this. Now, if you read the statute, there are exemptions from VAPA, but budget hearings, budget enforcement actions are not listed in those exemptions. And that's, I believe, important to note.
Okay, any other questions? Great, thank you.
Thank you, Chair Black. Thank you,
Thank you.
committee.
Thank you. Good to
Thank you
meet
for
you.
coming here. Okay, so, Jen, you want to come back up? This is exciting. You get to do markup and walk through on a bill other than 126. Jen Carvey did.
Right. Jen Carvey from the Office of Legislative Counsel. I think we are looking at the proposed amendment to this section, is that right?
So this is the amendment that, so I think we said there had originally in the Senate version been a section 7, they struck that out. The Green Mountain Care Board has asked that it be re-included. And now they've amended it slight bit more, and this is what they are requesting. So I'm perfectly transparent. The Green Mountain Care Board is requesting this language.
Yes, and to be clear, the section 7 was struck in the Senate version, put back in with the rest of section 7 that didn't address this issue. And so now this proposal will be striking out the Senate's section 7 and putting back in a section 7 that is similar to what was in the bill as introduced. So you'll also see language in here about the hospital fiscal years. So this would, in the language around the board's conduct of hospital budget reviews, it would add language saying, notwithstanding any provision of 3 VSA Chapter 25 to the contrary, which is the Vermont Administrative Procedures Act, the board's review, establishment, and enforcement of hospital budgets under this section shall not be construed to be a contested case. Any person aggrieved by a final board action, order, or determination under this section may appeal as set forth in section 9381, which is the board's appeal.
So the board, there is an appeal process where they can appeal, and that process is in statute in 9381.
Yes, it requires the board to establish procedures for administrative appeals and then allows anyone aggrieved by a final decision, final board order, action order or determination, I believe, is the language there, to appeal to the Vermont Supreme Court.
So there is an appeal process that allows someone to go to court.
Yes.
Okay.
And that applies to, across the board to the board's final action or person determination.
I got Daisy and Topper.
Jen, will you walk us through a plain language example of what this means?
And I'm not sure I understand.
Well, I guess I'm asking a lawyer to talk non-legalese. So the board reviews a hospital budget. You use in terms like aggrieved and get an order. Can you just say an example of like, if a hospital doesn't agree with the board's review, like I just need a plain language.
Yes, so any person who aggrieved is, yes, is dissatisfied, disagrees with, has a problem with a final board action, order, or determination. So I think you heard that the hospital budget decisions are in the form of an order. That any person in Vermont statute, unless otherwise specified, includes person or entity, so individual or entity, may appeal as set forth in section 9381, which is the board's existing appeal statute.
And you're saying they appeal to the Supreme Court?
Yes, the language in 9371, which maybe we should pull up here. 9381, sorry. Yep, oh, I do have that. Look at that.
Do we have that language that you just had up there?
Yes,
Yes,
it's on our website for today. It's version
Fairly recent, so you may have to refresh.
1 or 1.2. 1.2. 7.4.
This is 9381.
No.
Requires the board to adopt procedures for administrative appeals of its actions, orders, or other determinations. They would provide for the issuance of a final order and the creation of a record sufficient to serve as the basis for judicial review pursuant to subsection B. And then here's the language. We were just looking at any person aggrieved by a final action, order, or other determination of the Green Mountain Care Board may, upon exhaustion of all administrative appeals available pursuant to subsection A, appeal to the Supreme Court pursuant to the Vermont Rules of Appellate Procedure. And then there's a little bit more sort of procedural.
For my own clarity, and I know Topper and Leslie, so there already is in statute an appeal process for an aggrieved party on a final budget order. It takes away the contested case, which opens up, it doesn't consider it to be a contested case. And by not being considered a contested case, it's now not available to lots of other ways that they can appeal it. Am I getting the gist of?
So I am not at all an expert on contested cases. This is very far outside of my healthcare policy focus. So my understanding is that the contested case process in Title III sets out a process by which, unless otherwise specified, activities affecting rights. I mean, the legislature created the Administrative Procedures Act, so to my mind, you can not withstand the Administrative Procedures Act, and you do. So a contested case is a proceeding, including but not restricted to rate making and licensing, in which the legal rights, duties, or privileges of a party are required by law to be determined by an agency after an opportunity for hearing. There is a whole subchapter on what the procedures look like, application of the rules of evidence. And then at the end of that, there is judicial review. So if somebody who has exhausted all of their administrative remedies available within the agency and is aggrieved by a final decision in any contested case may appeal to the Supreme Court, unless some other court is expressly provided by law. So, and in looking at the, while we're all talking and looking some at the rules of appellate procedure, they contemplate cases coming to the Supreme Court, both from administrative actions under a contested case and not under a contested case process. So that is not determinative of whether a case can, whether a decision can be appealed to the Supreme Court.
So we're not taking away the aggrieved party's right to an appeal. We're just saying that the way they have to appeal is how we've put it in statute around the appeal process for the Green Mountain Care Board.
Yes.
Okay, Topper.
You just said half of what I was gonna
Oh.
say. I'm just gonna lay out a situation. I'm a hospital. I go before the Green Mountain Care Board. I get a decision that I don't like. After all of their procedures, their appeal procedure. Now I can go, instead of having to go to the Superior Court, which we took out, now I can go, the hospital can go directly to the Supreme Court to file that appeal. Is that the way?
I think that is what the language in the bill is, or in the proposed amendment is clarifying. I think I agree that the language in existing law.
Okay, we don't have any language now, it's out of it, it's taken out of there. What you just read on, whatever that number was, 39 something,
9381,
talked about the Supreme Court.
right?
Okay, so I'm the hospital, can I go to the Supreme Court? I can go, right?
If you're appealing from a final action.
Off the
or budget of the Green Mountain Care Board, yeah.
Going through their appeal process too, the one that they have in place.
Right, I don't know what they have in place. So if there is no process, then there would be no administrative process to have exhausted. If they have administrative appeals procedures in place at the board, the hospital has to go through that first. And if they're not happy with whatever that decision is, I do think that's a piece of what you have heard, and I don't know the answer to this, about whether there are administrative appeal procedures in place at the board currently.
Which I think Chair Foster laid out all their administrative.
Thought they did.
I'm gonna go Leslie and then Woody.
So the
Oh, I'm
answer
sorry.
to my question then is yes, right?
That's my understanding, is that they would end up at the Vermont Supreme Court.
Okay.
Leslie?
Well, that's where I'm a little stuck. I almost need a flow chart because I'm not sure I understand what the problem is if you end up at the same place, which is the Vermont Supreme Court, right? So you get heard there in the end, no matter, so you have a pathway. Why is one pathway more about, why is one party saying this and the other party saying that? I'm not sure I understand.
Can I ask, Mitchell, I'm sorry, my eyes are not, I was calling you Michael. What's wrong with the process in place right now?
So
If you don't like it, you can go to the Supreme Court.
you can, but if you have VAPA in place, then that's going to decrease the likelihood of having, well, this decision was ambiguous. We did not have process. Well, we would have process if you have VAPA. So right now it's Superior Court. That's what's in the statute for an enforcement action. This part of the language, not the part that doesn't speak to 9381, this actually streamlines it. This is not a bad thing because you're removing the Superior Court and you're making 9381 the consistent place that a hospital goes based upon a budget. So if it's your active budget that's been approved and you don't agree with the process, you can go to the Supreme Court. If it's enforcement, you go to the Supreme Court. That's a good thing. That streamlines it. But still, having the process be fair under VAPA before you go to that route, that would decrease the likelihood, in my opinion, that you would even have to go to the Supreme Court because you have a fair process.
Oh, okay.
Yes, you want to finish?
That's all well and good, but, there's a conflict here. People getting together to try to work it out. So, in my opinion, that's only my opinion. If I'm the hospital, I'm gonna take the route to the Supreme Court. And not gonna worry, I get the decision, boom, okay, thank you, Supreme Court. That's your appeal process. Because, correct me if I'm wrong, if you lose in the Superior Court, you still can appeal to the Supreme Court. So I'm saying, get rid of all that stuff and just go to the Supreme Court. Don't worry about anything.
Senator, if I may.
And that's in statute already. We don't have to do anything. It's in statute already. I know you're trying to block going to the Supreme Court, but
Would like to not have
Anyway.
to go to the Supreme Court.
the what?
Would like to not have to go to the Supreme
Yeah, I
Court.
get that, but I don't think that's gonna happen. That's what I'm trying to.
I had Woody.
Yes, how many times have hospitals gone to appeal their cases to the Supreme Court? Do we have a record? Well,
I can only speak to last year and this year. Rutland Regional went to the Supreme Court with Northwestern Medical Center, and then this year Rutland Regional is at the Supreme Court at this time. I believe UVM struck their case.
so there has been at least one time, there's some precedents, I guess, that you've gone to the Supreme Court, but it was kicked out.
So last year, the case before the Supreme Court, the court ruled, I believe it was Judge Cohen's opinion, that hospitals did not preserve the record for appeal, which I will say, thanks to the Green Mountain Care Board, there was a more defined process in this upcoming year, or this past year, in doing objections and having the ability to set that record. So that did preserve the record so that it can go to the court this year and in subsequent years.
And what's the reason for wanting, you want to have that ability, I guess, to go through the Superior Court first? Is that correct?
Not necessarily. That actually is one extra step. That's more costs. And then that just prolongs the process even more. And if the Green Mountain Care Board is overruled by the Supreme Court, then you have the question of what do you do now? So actually going straight to the Supreme Court as the appeal and removing the Superior Court, in my opinion, would streamline at least that portion of the process. But if we can not have to go to an appeal and it can be worked out before going there because of strong procedure, that would be preferred.
And have you had discussions with the Green Mountain Care Board on this item?
I have not.
Okay. And I guess there's no plans for future discussions on this section.
I'm not opposed to that at all.
Okay.
Mari?
Green Mountain Care Board, I believe, testified that there has not been precedence in court case until everything came to a head last fall. They also testify that VAPA would do the opposite of streamlining the process?
Can we, Mark, are you on? Thought we should probably have the attorney from the board on. Sorry, we've been struggling a little bit to,
Did you hear my
did you
question,
hear
Mari?
Mari's question?
I just hopped on. If you don't mind repeating, I'd greatly appreciate. Mark Hanks, their attorney for the Care Board.
Sure. The representative from Rutland Regional said that VAPA would streamline any contention between the board and hospitals around an enforcement. I thought that we heard from the board yesterday that VAPA would do the opposite of streamlining the process.
I understand. Thank you. So first, I just want to say, before I was a attorney, I was a human being, and this is complicated. So I appreciate the wrestling with the complication, and I also just want to say that Mr. Brody and I have a great relationship, and I really I think he's a great attorney, and I really appreciate his collaboration in a lot of places. So I'm glad we're all here. I'm going to share my problem as clearly as possible. First, I think there are two things in this proposed amendment. The first thing is clarifying that or changing the statute so that any enforcement appeal from the board would go to the Supreme Court and not to the civil court. And it sounds like Rutland and the board are on the same page about this being a clear path forward. It's how all of our other appeals operate. When a hospital appeals a board order, it goes to the Supreme Court, except for this one particular area. So getting uniformity there was our goal, and it sounds like Rutland agrees with that. So I'm not hearing any contention, disagreement there. The second piece is the part that I am hearing disagreement about. And I will say that, I'll just back up and say that I agree with Rutland that going directly to Supreme Court makes sense and streamlines the process. The part that I think I am hearing disagreement about is about whether or not the statute should clarify that contested case procedures don't apply. And that's what we're asking for in this amendment. And to really level set, I don't know how we do this. I don't know how we do enforcement going forward with the legal staffing that we have if contested case procedures apply. I just don't know how we do it. I think that if hospitals go past their budgets, we have to start making decisions about what budgets we enforce and what ones we don't. And my concern there is that everything else in S126 is trying to point us toward this goal of getting a lot more solid on total cost of care targets and getting a lot more solid on capping revenue. So the idea of the board needing to make decisions not based on policy, but based on staffing about whether or not it enforces budgets just doesn't make sense to me. So I want to say that, and I'll just add one more thing, which I think it connects to this question. Because we do notice and hearing, in my mind, the two big differences between what we do now and what Rutland would ask us to do are use the rules of evidence in a formalized way and allow for the cross-examination of board employees, of staff. and I think you heard from Chair Foster yesterday that given everything else we do in our process, requiring those two or having those two things need to happen as well is very burdensome to us, is not great for us with our staffing, and doesn't, I'm a little confused about what it adds in a meaningful way to improve this process. You know, all the information that we really, most of the information we get is from the hospital. The board evaluates what the hospital, communicates about why the budget why the budget overage happened. Chair Foster walked you through the analysis that our rule requires the board to use when it's evaluating. So yeah, that's my sort of longer longer answer than maybe you wanted.
Thank you.
Any other questions regarding this? Yes.
There was a question before Mark joined us about how many, Woody, I think you had asked how many hospitals had gone to appeal the Supreme Court. Was that the question?
Yeah, roughly.
Mark, do you know that number?
I want to make sure I understand the question. Is the question about appeals of the enforcement orders or appeals of budget orders?
I
And
believe
is it
it's
helpful if I
budget,
explain the go ahead.
budget orders.
Of the budget orders. So I might just know the last couple of years. I apologize, but we had a couple budget order appeals last year to the Supreme Court, and then UVM and Rutland and CVMC appealed their budget orders this year to the Supreme Court. So at this minute, there are 3 appeals. The UVM appeal will be dismissed under the settlement agreement as described there. What's new this year is appeals of enforcement orders, right? So the board establishes a budget with an order. That budget order can be appealed to the Supreme Court. The hospital lives in the budget for the year. If the hospital goes over budget, has excess revenue, the board goes through its enforcement process, which is what Chair Foster explained to you yesterday. And if the board decides to enforce an order by reducing rate for the next year, a new order is issued, and that order is the enforcement order, and that order is also appealable. Right now it's to Superior. We're talking about changing that to Supreme Court. This is the first year that we've had appeals of enforcement orders. And I did just get confirmation that last year was the first year that we had appeals of budget orders. So the budget order appeals are new as of last year. The enforcement order appeals are new as of this year. And those 2 were UVM and Rutland.
Would it be fair to say that with the hospital transformation work that we are doing from Act 167 and the anticipated things that we are doing in S126, in the reallocation of scarce health care resources in the state, that the Green Mountain Care Board would anticipate far more budget appeals and budget enforcement appeals?
My experience so far has been just in watching states make big changes, is that big changes can create more lawsuits. So I'm really hopeful that that's not the direction we're moving in, but yes, that seems very possible.
Which would mean we would need to significantly increase the resources that we allocate to the Green Mountain Care Board for
Yeah, and frankly,
fulfilling their statutory duty.
Yeah, and add a lot more. I mean, we're not asking for more attorneys. You know, I think what we're asking for is a rational and expedient and and fair, balancing those things, process for the board to evaluate overages and for hospitals to have an opportunity to be heard that doesn't hamstring the board from actually being able to enforce its orders, to make its orders mean anything, right? So we're looking for some balance there, and this to us is the way to strike that balance.
If we were to approve this amendment and pass S-63 amending what the Senate has, knowing the immediacy of the environment that we are in at this current moment, would it be possible for perhaps parties to get together in the next year or so to make sure that what we actually have in statute is clear, clarifying, unambiguous as to enforcement of hospital budgets and hospital enforcements, to ensure that everybody's working under the same expected rules and that it's a system that works for everyone as we go into a very, very difficult and what we know will be a contentious environment in the next years. Would you commit to working with other interested stakeholders to ensure that the system is not being abused, I guess is what I'm going to say?
Easy yes.
Okay.
Easy yes.
Okay.
And I think I think that the system we have right now has a lot in it that's in rule and that's in policy. So I just want to state out loud that the high overarching what's in statute is what we're talking about at this minute, and there's a lot underneath statute that can be that either is good as is or could be changed, right? That doesn't require statutory changes.
Okay, great. Thank you both. All right. So I know it is 12:05. Does anyone in this, well, first of all, Jen, have we completely gone through?
No,
We haven't even gone through.
there's not that much more.
There's not that much more.
I do also want to clarify, I misspoke earlier on the court rule I was reading. I don't think it really affects what your conversation is like, but the rule was a rule of civil procedure about appeals to the Superior Court, not to the Supreme Court, so it's sort of irrelevant. What am I trying to put here? 63.
63.
The rest of the amendment, that was the first piece of the language. The rest of the amendment keeps in the different dates for the different types of hospitals for their hospital budget fiscal years. That is unchanged from what is currently in the bill and really only has meaning for Brattleboro Retreat. And then the other piece is to strike this language. So this is in the enforcement section. And striking out the language saying hospitals may appeal any decision in this subsection, which is the enforcement subsection, to Superior Court. Appeals shall be on the record as developed by the board in the administrative proceeding, and the standard of review shall be as provided in Title 8, because this was originally language under BISHCA, now DFR. And so that is a reference to the standard of review for the commissioner of DFR. So it's sort of out of place in here. Anyway.
So we're striking this out, and this section only applies to enforcement, and we don't need this because enforcement is under the normal appeals process.
Right, I believe this is enforcement, so it's under subsection H. If a hospital violates a provision of this section, and then what the board can do, and what the board may order hospital to do, and then talks about orders issued after notice and an opportunity to be heard, except where the board finds, and this is existing law, that a hospital's financial or other emergency circumstances pose an immediate threat of harm to the public or the financial condition of the hospital. In which case the board can issue orders without written or oral notice, but allow for a hearing after the fact.
Any discussion on the bill? Any thoughts?
And our other change.
I'm sorry.
Also, nope, I just forgot there was this completely unrelated piece to this is around effective dates and specifying that in section 5, which is the ACO, the board's regulation of certifying and budget review for ACOs, the subsection on certification would take effect on January 1st, 2027. The remaining provisions would take effect on January 1st, 2026. So this would continue to have in place the existing provisions until January 1st of 2027 around certification of ACOs.
So when we first saw the whole bill, got it over, it had all those other sections, and this is how we're proposing to amend Senate's bill. So
Exactly. You'd be
just-
amending it just in sections 7 and 10. I did not do it as a strike all.
Yeah.
It's like a 24-page bill.
Sometimes I think strike calls are nicer.
Yes, but it can be hard. It's a 24-page bill and you are changing 2 sections.
Any discussion, any thoughts? Not. I'm going to entertain a motion. We amend the Senate.
You're doing a real vote?
Yes, this is the
This is a
committee's
bill.
amendment
This is the committee's amendment, so yeah,
And
we need a,
and then reporting. So yes, this is the report of the committee.
So first we do the straw poll and then
oh,
the
yes,
amendments,
that's right. We do a straw poll to amend. And then,
I'm coming into the room, so can you
Okay.
just give me a minute?
sure,
Thanks.
Louise recording. I think, Leslie, did you agree to?
No, I did not.
Take the weekend to think of it.
I need a reporter of this bill and I'm sorry, I cannot. I don't have the capacity for 126 and 63, so I need a volunteer. I volunteer, Brian.
I don't think so.
I'll second.
You don't get the volunteer, the people see things.
I'm only kidding.
Alright.
Okay, we'll find a reporter of the bill, but I need a reporter of the bill. I will.
Oh,
Oh, thank you, Wendy.
Aren't you the best?
Thank you, Wendy. Thank you, and we'll support you. Well, let's see if the bill passes first. Committee, let's do that. So we are, moved, or no, I don't even need a motion. All in favor of amending the Senate bill as with draft number 1.2. All in favor? So we are. Keep your hands up. I have 830. And then I would entertain a motion.
What did we,
Right, I move that we, the House Healthcare Committee approve S63 as amended.
Second.
Clerk can call the roll.
Representative Chena.
Yes.
Representative Portis, yes. Representative Critchlow,
Yes.
Representative Demar,
No.
Representative Goldman,
Yes.
Representative Houghton,
Yes.
Representative Page,
No.
Representative Powers, no. Representative Rebecca,
Yes.
Representative McFawn,
Yes.
and Representative Black.
Yes.
The motion passes on a vote of 8-0.
Great, and Representative Critchlow will be reporting this bill with a lot of support from.
Thank you.
From committee members. Thank you, everyone. We'll see you back at 1 o'clock.